Marjorie McLean, corresponding member 479, one of the team ministers in the Orkney Islands Church of Scotland and convener of the Legal Questions Committee. Moderator, the Legal Questions Committee is one of those blessings to the Church, its small procedural committees. And this one consists of specialists whose collective experience and skill help to safeguard the Church's activities as a legal institution. This year, I would characterise the committee's work as falling into three types. First, we have supported those who have had responsibility for designing some of the largest changes in the Church's life in recent years, who will report on their work elsewhere in the course of this week, indeed to some extent already have. Often our role is to spot the consequences in what they are doing for existing regulations where innovation is directly taking place elsewhere. And our task becomes the drafting of the new acts or regulations to assist our colleagues, and then any necessary amendment of existing laws to keep everything consistent. In that category of activity, I would include the completion of the legislative passage of the Presbytery Review Act, several small amending acts prompted by changes in our practice in various areas, and our raising of some queries relating to Act 1, 2015, that's the Act regulating the ministry of those in same-sex marriages or civil partnerships, queries raised especially by developments in team ministry. I'd like to thank the Principal Clerk and her staff, especially the Deputy Clerk, for undertaking the drafting of the legislation that appears in the reports of many bodies through this week. Second, we've done various pieces of work which should improve the effectiveness of the General Assembly and also of its disciplinary bodies. This, of course, includes the redrafting of the standing orders we dealt with this morning. It also included a major piece of work undertaken by one of our working groups over 2 years to improve the complaints and disciplinary processes of the Church, to benefit both those implementing them and those subject to them. Also in this category comes the small adjustment to the regulation of the Commission of Assembly. That's the body that meets to transact business belonging to the General Assembly itself, but business too urgent to be left until May of the following year. And this minor change will enable the Commission for the first time to pass legislation, although only provided that it was necessary within the view of the previous General Assembly. And third, we're always keen to assist those who find themselves involved in the courts of the Church, especially those suddenly having to learn the ropes as, say, brand new elders or perhaps as first-time commissioners to this court. We very much hope that that writing of the standing orders makes them clearer and easier to understand, whilst also slightly simplifying some of the processes of the Assembly itself. The same motivation to help everyone to feel confident and comfortable in their roles in the courts and agencies of the Church lies behind the planned production of a book designed to be given to those at the outset of their involvement in our governance. It will be an introduction to the general principles of how we do things, rather than a summary of all the detailed regulations and practices which have an annoying habit of changing. So those things are much better contained in that wealth of information that is to be found in the legal pages of the Church's website. The members of this committee are what I would call behind-the-scenes people, in common with those who serve on other technical trusts and committees that will bring reports this week. It's our privilege to play this kind of supportive role alongside more visible colleagues in larger bodies as we help them in what at the moment are very difficult tasks. So I present the report of the Legal Questions Committee, and with the exception of the Section 2 of the deliverance, which we've already dealt with, and Section 3 of the deliverance, which will come up later this afternoon, I would ask the Principal Clerk otherwise to move the deliverance on our report. Thank you.
I so move. Seconded.
Thank you, Marjorie. Are there any questions to the convener on the report as a whole? None have been logged. So we turn to the deliverance. Firstly, receive the report. And online. Sorry, I'll get this and online by the end of the day. Section 2 we've taken. Section 3 we'll come to later. Section 4 we have an amendment in the name of Brian Kerr. The clerk will read the text.
Thank you, moderator. Name Brian Kerr. So add at the end of section 4, subject to amending the Amending Act as follows. In paragraph 2, the new section 40 in subsection 41, Roman numeral 5, delete the words payment of stipend and other benefits shall be suspended for the fixed period, and the lights are so bright. And also delete the words payment of stipend and other benefits shall resume, and further consequently amend subsections 42 5 Roman numeral, 43 5 Roman numeral, 44 you get the picture, 40 2 3 4 5. And don't worry, those bits are correct, to remove reference to suspension of payments and their resumption.
Thank you. Is the convener willing to accept this? No. Brian.
Moderator, thank you.
Oh, sorry. Is it seconded? Seconded.
Moderator, thank you. Kerr 212. Moderator, I'm here as a minister of a parish minister in the Church of Scotland, but also I have the privilege of journeying alongside ministers as one of the workplace reps for Unite the Union. And it's with some of my colleagues that I raise this with them in mind. When we get to the list of censures at the back of the Act, I'm grateful for the tidying up work that the Legal Questions Committee have done. However, the role of a minister and the life of a minister is a very complicated one because it is bound up in both the role and the place, physical as well as spiritual, of the minister in a community. And if after a period of administrative suspension, which through no fault of anyone can last upwards of a year or 2 years by the time processes work their way through, a time when they're suspended with no hint of guilt or otherwise.
Sorry, I apologise to disturb you mid-flow, Brian.
That's okay.
Because we always enjoy you mid-flow. But can I just literally double-check with you? You said the words administrative suspension.
No, beforehand, yes.
So this section's about judicial.
That's right.
Just wanted to get that clarity. Thank
you,
Brian.
No, what we're talking about is they've been suspended for some time whilst a process is ongoing to get to the point where they've been through a judicial process and that's it. So there is a long time that a minister can be off and before it gets to this point. Sorry, was what I was trying to say. A fact that we have a 3-month suspension where a stipend is stopped and other benefits, but those other benefits are not clearly defined, causes me a little bit of an issue. A minister, for example, stays in a manse and will be permitted to continue to stay in a manse during that period of suspension, but yet who's responsible for things such as council tax, which can only be paid by a charity for a minister who's benefiting and involved with that congregation. We're reading in the General Trustees report that there are problems with occupying a manse on a caretaker basis, and how would these type of things play into that? Yes, a minister, if they have done wrong and been found guilty, needs to face the consequences. No one should ever dispute that. by not allowing or by removing a stipend even for those few months and having a minister seek other employment may seem the right thing to do. But if a minister is bound to a community because of the home in which they live or the position which they hold, and they only live in that community, it may be a small community because they are a minister and there's no other employment capability, then what does that mean for us? We also have, as a church, to keep in mind the relationship ongoing with the congregation and with the church. To take a second job, ministers need permission. To work from a manse and run a business, ministers need the express permission of presbytery as well. Moderator, I'm concerned that the removal of stipend for such a short period as this may cause some more problems than it seeks to solve. Ministers are punished in many ways when they are suspended, and this is not one by doubly punishing them because they can't get other work and because the stipend is removed is not one that I think we ought to look at. Moderator, I raise this because I think it is important for our ministers to have clarity. There is the suspension where pastoral ties are dissolved, where it lasts longer than that period. Again, that seems right in those most serious of cases. But for a period of 3 months, where a minister is bound in a community because of the role that they hold, living in a manse that they may not be able to afford normally on a stipend, and also where there are no employment opportunities locally. Moderator, I worry that this will mean that we lose ministers not just for a period of 3 months, but fully as they feel they have no option but to move on. Moderator, I think this needs removed for the simple fact that this could be exceptionally problematic going forward. And Moderator, I do support the committee in everything it does, but for this part, thinking of the ministers that we support through the union, I would be derelict in my duties if I did not raise such a matter.
Thank you, Brian. Grant Barclay as the seconder, and then thereafter Gordon Kennedy.
Grant Barclay, 152. Thank you, Moderator. I speak not as a parish minister, but rather as a presbytery clerk, charged in part with the implementation of censures, but also the pastoral care of ministers. And I've got 1 or 2 quite technical and detailed issues which very largely orbit around my concern about the phrase "and other benefits" as they have appeared in the proposed draft legislation. So I think I was simply going to express my disquiet at this stage because, in fact, I've had some conversations with the convener. I'm most grateful for her clarifications. But now that Mr Kerr has raised this, I feel that it is appropriate to second it. There are issues in relation to these other benefits which relate not only to the manse. My understanding is that the payment of national insurance contributions, which will have a consequential effect perhaps on a minister's pension, and the payment of the DC pension contributions are also likely to be suspended for the 3-month period. I understand that the death in service provision shall not cease, but it would be dreadful, Moderator, if during that period something dreadful happened and a man's family were thereafter significantly and permanently disadvantaged. I'm quite happy that there is some assurance that that cover remains in place, but it doesn't say so in terms of the Act. And my concern is that withdrawal or suspension of payment of stipend and other benefits potentially leaves ministers in a place of some challenge in relation to comfort over these matters. I should say as well that not only is it possibly the case that there are practical difficulties in obtaining employment, perhaps in a small community, but Section 16 of the Parish Ministry Act prohibits a minister from seeking and undertaking any paid employment without seeking the permission of presbytery. And as a presbytery clerk endeavouring to work all of this through, I can see real challenges with, on the one hand, imposing the censure, and on the other hand, endeavouring to seek presbytery's permission to permit a minister to obtain employment for a short period in order to try to mitigate what could be around £9,000 worth of reduction were the whole 3-month suspension at current stipend rates imposed. So I simply say that I trust what the committee is doing. My sense is that removing these words this year does not prejudice the bringing back of additional and clearer words next year, and I'm therefore pleased to support Mr Kerr's motion.
Thank you. Gordon Kennedy and then Thorsten Koenig.
Moderator, Gordon Kennedy, number 13. I want to ask the Assembly to resist Mr Kerr's motion, not least because, as we've already heard from Mr Kerr and Dr Barclay, this is an immensely complicated matter and somewhat technical, and I have huge concerns about a body like the General Assembly amending the terms of acts of the Assembly, as it were, on the hoof. Over the past 10 days or so, I've had some correspondence with the convener, the deputy clerk and the solicitor of the church specifically about this matter, because the phrase "and other benefits" caught my attention on reading the report. I am greatly comforted as a result of that correspondence. This is not a new measure of sanction being introduced this year. That should be made clear to the Assembly. We are not bringing in a new thing at this point. This is already an existing sanction. If we remove the phrase "payment of stipend and other benefits," the question becomes, what on earth does this sanction achieve if it is applied without the removal of stipend and other benefits? It simply means nothing. And that illustrates the complexity of trying to unpick the text of acts of the Assembly during debate at the General Assembly. I am greatly comforted that the committee will keep the specific wording of such things under review. And having had correspondence this year, in particular the phrase "and other benefits" will be clarified going forward, so that everybody knows exactly what's included and exactly what's not included. But to try and unpick this afternoon, I think would be unhelpful, and so I would ask the Assembly to resist Mr Kerr's amendment, counter-motion, addendum, delete as appropriate. Thank you, Moderator.
Thank you. Thorsten?
Thorsten König, 129, and as a minister, a new kid on the block, just in January ordained. Just 2 questions for clarification. I heard under other benefits, the MANS is excluded. So just to confirm if somebody is exposed to that, has to move out of the MANS for 3 months or not? So thank you. And secondly, there is a whole catalogue of accelerating consequences. Could the convener just give an idea for this fixed term, what circumstances would trigger such a disciplinary matter, just for the General Assembly to learn what the purpose of this is, 3-month suspension?
Convener? Just on that for now, and you'll get your right to reply at the end.
That is entirely up to the disciplinary tribunal. If commissioners look at the palette of censures that would now be available, I imagine you could put onto that as a grid a kind of increasing severity of disciplinary offence. I think there's a little bit of circularity here, in that presumably the disciplinary tribunal is going to take into account the fact that a suspension of up to 3 months would have these financial effects, and therefore would regard it as being as serious a censure as that, and therefore applicable only to a fairly serious disciplinary offence. It is very difficult to answer questions in this area because it's almost impossible to do so without alluding to or hinting at actual cases, and we would never ever refer to those here.
I understand the Procurator. No, sorry, Solicitor. Mary.
Get my mic on.
That's you.
Yes, yes, success. Just to let the Assembly know, one of my least pleasurable duties is as serving as the clerk to the Discipline Tribunal. So I do have an unfortunate intimacy with the sort of offences which result in suspension for short periods. And it is the sort of conduct which, in employment terms, you would classify as gross misconduct. It's the sort of conduct for which one might be dismissed where an employee. So it's pretty serious misconduct. It's not for offences at the first level. So just to give the Assembly that assurance.
Brian, just before I give the convener the final word, anything you would like to add briefly?
Moderator, thank you. Kerr 212, thank you for the time and allowing me to raise this today. I think this is immensely complicated because it does deal with people's lives, and any situation which does that is always complicated, particularly on the floor of Assembly. I think my concern, to come back to what Mr Kennedy said, is that effectively, although this is a suspension for a fixed term, it really does amount to a fine more than a suspension, particularly with the resulting issues around other employment. And that is not necessarily where I think we want to go as a church with discipline offences. I'm so grateful, and I almost hesitate to say this, I'm so grateful to those who draft this legislation and respect them hugely. But Acts needs to say very clearly what they intend to say and do, and I'm just not sure that this one does that in this very particular statement, as Dr. Barclay mentioned about the other benefits. I think it's leaving us with questions, it's leaving us open to an understanding. And yes, we might be able to deal with that in guidance notes, etc., but they change depending on practice and depending on circumstances at the time, on occasions. I think removing this year does allow, as Dr. Barclay says, the committee to come back with clearer guidance and clearer instruction next year on this. But for right now, because we don't have that clarity, I think it would be wrong of the Assembly to pass this section, and I would urge the Assembly to support this motion. Thank you, Moderator.
Convener.
Thank you, Moderator. A few things just as they came up, I think, in the debate. As Gordon Kennedy has said, this is not innovative in any way. The understanding is that the non-payment of stipend would already be the case in fixed-term suspensions. The innovation is that we are reducing the maximum length of those from 6 months down to 3, and so, in fact, mitigating that kind of effect by meaning that it could only be for that shorter time. The question about needing permission from Presbytery to have another job, surely the spirit of that rule is so that you don't have people trying to be a minister and simultaneously doing another job. And I would have thought if somebody wasn't being a minister because they were suspended, there would be absolutely no reason for the Presbytery not to permit them. In fact, I'm not even sure they would need to be asked for the minister to be able to have another job. I think when you're not sure about a rule, always ask what is it trying to achieve and what mischief is it trying to avoid. And I cannot imagine that any presbytery would have a reason to prevent a minister from getting temporary appointment while they are not able to act as a minister. So I don't think that's a problem. I hear that Brian Kerr is speaking partly from the point of view of the union membership that some of our ministers have. And that always kind of brings parallels from civil employment into our minds, sometimes reasonably and sometimes not so legitimately. I did earlier have a little look on the gov.uk website and asked it the question whether when suspension is used as a punishment rather than just administrative. Is it ever possible for remuneration to be stopped? And the government tells me that yes, it is possible to do that, as long as it is specified in the person's contract of employment and as long as the employer is being reasonable. You have to translate that into Church of Scotlandese. I think the equivalent of the contract of employment is the law of the Assembly, and reasonable is what the General Assembly decides it is. So this is certainly something that legally is recognised in civil law, if that is a parallel you want to think about. The ancillary benefits, I understand from the solicitor that council tax would still be paid because the property belonging to the church would still be occupied. I understand it may be possible to ensure that some element of death in service is continued. I think that's a conversation that is being had. I'm slightly less sympathetic about employees' national insurance payments and pension payments. These are both things that can be topped up by an individual, and if for disciplinary reasons you're not receiving the equivalent of stipend, then I don't think in any other walk of life you would expect these ancillary payments to be made, and they can be compensated for. So I think that's just one of the implications of what has happened. I was going to finish, and Gordon Kennedy beat me to it, by saying you do need to make sure that a punishment is a punishment and not a holiday. I think a disciplinary tribunal will consider, as I said earlier, the financial implications in deciding whether the conduct that's being looked at is sufficiently serious to warrant a censure that has these implications. I would like to think that a minister being told that they couldn't exercise their ministry for 3 months would feel that it was punishment not to be able to fulfill your calling. But I think it's not unreasonable to say that alongside that goes the other part of it, which is the more patrimonial implications of fulfilling that calling, and it would seem odd for those to be excluded. So I would defend what we've got as we've got it.
Okay, so we come to moving for or against the amendment. And again, this will be an electronic vote. Sheila.
So we have the amendment in the name of Mr. Brian Kerr in the hall. If you want to vote for his amendment, it's button number 1. If you want to vote against his amendment, it is button number 2. On the hub, the buttons are for and against. So the voting is open. Five seconds. The vote is closed.
They voted for the amendment 92, against 198, so the amendment falls. So we turn to Sorry, section 4 as in the print. Section 5 and online. Section 6 and online. Section 7 and online. Section 8 and online. Section 9 online as well. Section 10, the report as a whole. Oh. Okay, so section 10. And the sorry, we've got one still to take. So we'll hear from the convener again in just a few minutes. We move now to the report of the Presbytery Review Committee and the convener, Moira MacDonald.